All right. So by and large, we are talking about administration of estates, and like I said before, we have people when you die with a will, we say you have died tested, and when you die without a will, we say you've died intestate. So there are different processes and procedures under either case. And in this case, when a person dies and there is a will, whether that will is brought before the burial or after the burial, because it would depend on circumstances, because the people who are keeping your will probably know about your death. And maybe they also have further instructions like, when I die, bring this will, let it be read, and such that if there is anything that needs to be done before I'm buried, it can be done. But by and large, um, when you have a will, you can't just open and say, oh, I have received the car, therefore let me put the key and I drive it off. No, there is a document we call probate. So when you have when the will is read, the executors will require services of a lawyer to draft a petition for grant of probate. Now they will attach the will, they'll attach identification, they will attach the death certificate. Of course, we all know that right now, NIRA is one of the big entities when it comes to registration of persons, both birth, marriage, and death. So you'll need to have a death certificate, then you attach the particulars of the applicants, you attach that will, and then you submit these documents to court. Now, court has also the internal processes. They'll have to identify these people. They'll have to see whether somebody is going to come and contest. I think there is also advertising the notice in the Gazette or in the newspaper of wide circulation. But by and large, when court is satisfied that all requirements are complied with, they will give you a document which is called probate. So this document, it will be written on grant of probate. Now, probate is the authority you use to implement the clauses of the will. So let's say there is land, and that land is of course in the names of the deceased, who is the testator, and he has willed that land to Bravo. And now the executors, to make sure that Bravo you get that land, they'll have to get the probate and then the will, and then they go to the lands office. They sign transfer forms. When it is in the second part of the question, under, for example, administration of estates where somebody doesn't have a will, they first transfer all the properties to themselves. So here the executors will put the land or the assets in their names, and then with the power of the probate, they will begin transferring these properties to the respective beneficiaries.